Well, good morning. It's a pleasure to be here. First, I want to thank TMA and Joyce for putting this together. It's a great pleasure to be, again, speaking to a select audience like we have on the TMA. Professor Adriana, thanks again for putting this together and helping us to organize. I think we're going to have a great hour and a half here to talk about very interesting issues. I'm happy to be joined also by my colleague Andrew Witts from Gowling, London. I've known Andrew for more than 15 years. He came to Brazil first to work on a very famous case that I think most of us know of, which is the Maluf case. Interesting enough, and I think he's going to have the time to talk about it, there's insolvency became a big piece of the case. So, Kevin, which I've known for many years as well, acts as a liquidator in very interesting jurisdictions, from Vietnam to Cayman Islands to London. So I think there's a lot of interest topics we can bring to these events, and we hope we can, dig deep into as much as we can of the issues around. Of course, we'll try to do, some connections with the Brazilian system and how do we take this forward from a Brazilian angle. And Nyana Miller, who I'm glad to work with on a number of Chapter 15s. I think her firm, Sequor Law in the US, has done many Brazilian-related Chapter 15s. And she also, she's half Brazilian, so she could do this conference either in Portuguese and English, but today, for the benefit of the international audience, we're going to keep it in English. Nyana, can you hear us? Hello? Can you hear us? So should we? Can you try to reconnect, Nyana? Maybe. Yes. Maybe that's a good. I don't think she's here at all. Yeah.
I could hear you, but for some reason it's cutting out, so I only hear like every third.
Yeah, we heard you now, but it's cutting.
Yeah, it keeps freezing up.
It got better, though. What about now?
Okay, good.
Excellent.
I'm sorry, I didn't hear the question to me.
There's no question, actually. I was just
the introductions very well.
Yeah, I was just introducing you. So Professor Adriana, do you want us to, each take, like we talked, a few minutes to talk about our experience, where we're from, what we do? Or how do you want to handle this?
Me? I don't want to be in the middle of you guys. We want to hear from you. Good morning, everyone. It's quite a pleasure to be here. Thank you, Joyce. Thank you, Otaviano. Thank you, Henrique. We are so glad to have you guys here to talk about this really important subject, because I think not only in Brazil, but people who don't work directly with this subject, we have so many questions, and maybe we have the false perspective that this is kind of really difficult to do. I mean, to recover assets when they are moved from jurisdiction to other, to difficult creditors' rights, and we would like to hear about you. I suggest, if you were on with me, but to you to talk something and introduce the subject for like 5 or 10 minutes, and then after that we can discuss. I have some questions for you, and I think it's going to be great to be with you all. Thank you all.
Excellent. So I think for the benefit of the Brazilian audience, I should go first, just to give an introduction from the angle I think we're going to be looking at. And then, of course, Nyana, you and Kevin and Andrew can jump in with your perspective. So it is. You're right, Professor, that it's quite complex. It demands a lot of resources. a lot of people that know what they're doing in a different number of fields, not just lawyers or judicial administrator, but most often you're going to use forensic experts. You need to have a team that you can coordinate efforts in different jurisdictions at the right approach, because sometimes key evidence from a jurisdiction is going to be necessary to be used on other jurisdictions, especially when you get to the offshore jurisdictions and Switzerland and Monaco and places that tend to be more protective of financial information. There's a lot of legal rights to people that use those jurisdictions to protect value. So from a Brazilian angle, I'll tell you that I think our market is probably one of the best in the world in terms of having the legal resources, the judicial certainty. So, I mean, as an insolvency practitioner, as a lawyer acting on insolvency and fraud-related cases, I'm very comfortable in being and filing applications in our systems. Our judges are sophisticated, and our law is very good. I mean, the Brazilian law, I think at this stage, I don't know if I'm but I do defend and say that we're likely going in the direction of having the best legal resources available in the world. And the reason for that is that we do have statutes and legislation that allow us to make applications to the courts. But we also now, the new changes, the use of precedents, case law, is going to only take us in the right direction. Because if you look at every single ruling, particularly in the state of São Paulo and some other states that have dealt with the issue more often, the judgments are quite, interesting. They are effective in terms of what you're going to be applying out of those judgments. And the SCJ, our highest courts on civil matters here, has issued a number of different decisions that are favorable to the asset recovery, particularly coming out of an insolvency proceeding. So one of the things we have been using in Brazil for a while, and at least I haven't seen case law against it yet, is the kickoff by using a sealed file. So we have here former judges and prosecutors that have dealt with this type of files before, but our courts are comfortable in a fraud situation to give the insolvency practitioner and the state some time to put the plan together. And that requires the use of, gain access to tax information, to sometimes, the bank information, and we can go into that little bit later in the conference about what is the secrecy for the states. Sometimes we see judicial administrator having a difficult time gaining the access to the information of the company, of the debtor, and that's your information. You should be able to use it at any time. But our courts have said a number of times, including the SCJ, that these files, depending on the situation, should be used, are not only allowed to be used, but they should be used, because that's the way the judicial administrator can bring efficiency to the proceeding. So in those files, it's where you're going to report and ask the assistance of the court when necessary to communicate with other courts. So Nyana is going to talk about Chapter 15 and the communication with between courts when she speaks. But I think that's one of the key case law we have in Brazil. Judicial files are not illegal. They should be used with, of course, respect to due process, secrecy, when proper. So our court says that you don't need to give due process in the first stage. Sometimes you don't even know who you should be giving due process to. So on this case, the courts have said you can always do this in a second step. So I think that's the number one kickoff, I would say, that our proceeding has. And in other jurisdictions, sometimes it's quite hard. They don't have these the courts require much more evidence to show who is the fraudster and what you're going after. I think our courts are well balanced in terms of what they allow us to do. Now we have, again, the cross-border model law, which we can talk about it later, but we always had the possibility of using the cross-border model law, taking cases out of Brazil to foreign jurisdictions. So I think Nyana can give us a few numbers, but I believe Brazilian proceedings represent something like 80% of the Chapter 15s on liquidations, full liquidations, bankruptcy, filed in South Florida, for instance. And that's, of course, sorry.
I haven't actually seen the numbers, but that is consistent with my discussions with our judges here in South Florida. I'm keeping my when I have the video off.
Yeah, your second phrase got cut, but there's a reason, of course. I think Brazil is one of the biggest traders with South Florida, and of course, you know, a lot of Brazilians that use the offshore jurisdictions tend to have an apartment or some type of connection to Miami and South Florida, and use, you know, legal practitioners and accountants and financial advisors located in South Florida. But I know at least of over 30 Brazilian cases that were filed before we had the model law in the United States, New York or South Florida, and were recognized, and the judicial administrator then had the powers to investigate and use the US style of discovery to put together whatever claims that he couldn't benefit of the state. So I would think that on those legal grounds for insolvency, we're quite well. And it tends to get better as the judgments continue to come in from the higher courts. Also, another point which we are familiar with, but for the benefit of the foreign participants here, Brazil has by far, the best electronic system of freezing assets. By far, I mean, whenever we talk about it globally, people come over to me after the conference and say, how can we get it? You know, if I were, you know, head of central bank, and I would sell the system because everybody loves it, and it keeps. I'm concerned because it keeps getting better. It might be that one stage they're not going to need us anymore. But you know, now we heard about this sniper situation and what it can do, and I don't know if people had a chance to see it, but it's just crazy the type of information you get back. Power of attorney, companies, connections. They even give you kind of an I2 chart that you can see it. So it's and this is available, you know, and it's quite fast on how it's going to be giving data to us. So all these cases about fraud and asset recovery is really in the beginning about putting data together. You want to know what happened, if there is a fraud, of course. How do I prove the fraud? And where are the assets, right? And who are the third parties that helped put this fraud together? Are they liable? Should they be sued? Is this, because this is a part of the asset recovery as well. It's not just going after the assets. It's also suing on behalf of the states, third parties that help that happen. So I'm going to stop here from the Brazilian side, but I'm very, you know, I've been around the world on a number of these conferences, and I do believe we are likely heading to be, if not the #1 jurisdiction on what's available to the practitioner, at least on the top 5 for sure. So I want to maybe turn over to Nyana to give us some inputs about Florida, and then back to you guys in the European and Caribbean issues.
Wonderful. Well, good morning, everyone, and thank you for the invitation. I apologize in advance for the technical issues. I hope you can hear me all right, and I wish that I could be with you there in São Paulo. So as Henrique mentioned, you know, we do work together on a lot of cases. I am Brazilian by birth, although I never had any legal training in Brazil. So as an American lawyer, I basically American judges. So when the bankruptcy trustees need to come to the United States, whether it's for discovery, like Henrique mentioned, you know, getting access to bank account information, or, you know, So, you know, we filed the petition for recognition here in Florida. And then because of the way our discovery process works, we also run all of the discovery as a law firm, right? So in the US, about the discovery that's being taken, but until that point, the discovery is filed in the court record, but it's just issued directly by the law firm to the person who needs to answer, who's, you know, in many cases a bank, sometimes a real estate company, if the debtor has real estate here, sometimes accountants. And so we issue that discovery directly. and deal directly with receiving the documents. Also, another point that is a little bit different from Brazil is that when we receive the discovery, so Enrique was talking about sealed files. In general, our proceedings are open and transparent, and they're not under seal. We would have to specifically request that. In many cases, we are not able to request it. But the discovery itself, the financial documents that we obtain, are not themselves public, right? So until the point at which we need to use those documents to make a claim against someone, those documents just basically sit with us, and we can give them back to the client, of course. So they sit in our law firm, they go to Enrique's law firm, and they go to the client. The judicial administrator in Brazil has access to those, and they can use them to bring claims here in Florida, in the United States, also in the Brazilian proceedings. So we've seen some cases where, interestingly, the money flowed through the United States, but the fraudulent transferee, the ultimate recipient of those funds, was back in Brazil again, or in an offshore jurisdiction. So, we have to bankruptcy estate, but we do not have restrictions on the jurisdictions where we can use that evidence.
Yeah, I think that's a key point that Nyana gave us, and I just want to complete maybe because it got a little bit cut off still, Nyana. We can hear you, I would say 80 to 90% of what you're saying, but yeah, I think one of the benefits of the US discovery is that where you can use it on other jurisdictions tends to be more flexible. The courts are more open in terms of the data you get. And we even, the way we approach it is we try to follow every rule connected to the case. So if it's a Brazilian case with a US discovery and a Swiss bank account, we're going to follow Brazilian law, US law, and Swiss law. Because that's the only way you can fight fraudsters, or else they're going to find a way to delay you, to stop the proceeding from going. But my friends here that are in the panel, they have worked in a number of different jurisdictions, some of it in Asia that we have less contact with. But usually fraud cases, you're gonna be dealing with a number of different jurisdictions at the same time. I know of a case that Kevin and Andrew are working on that had at least 5 jurisdictions. So appointment in BVI, bank accounts in Switzerland, Zurich, and then US discovery. So I would like to ask Andrew and Kevin, one of you, to kick off by giving us an approach of the Caribbean jurisdictions, London, the English system of looking for assets and what's available to insolvency practitioners.
Thanks, Enrique. Just by introduction again, thank you for inviting us down here. Very nice to be in Sao Paulo on a rainy morning. That makes us feel completely at home from London. So that's always a good start. My name is Kevin Hellard. I look after the insolvency business in Grant Thornton, UK. And the relevance to that is that also includes everything we do in the offshores. So the Cayman Islands, British Virgin Islands, Hong Kong, Singapore, Cyprus, and others, where we have our sort of various offshore jurisdictional experience. And to try and put into a context this process, I spent many years investigating and recovering assets through fraud. Many years working with Enrique and his teams, and done a lot of work with the teams on Brazilian cases as well. And I reiterate Enrique's observations of the court systems in Brazil. Certainly very proactive and reliable, which is very different to other jurisdictions. But the context of it is when you are involved in significant frauds, and we talk about significant frauds here, there is always, only when you're dealing with, you might be dealing with a government, you might be dealing with a substantial corporate, and I was always faced with the problems where people say the first thing they want to try and do is to plug the gap, want to plug the hole, to make sure it doesn't happen again. And almost the recovery side was secondary. And let's try and get an educational piece to get people to get to the stage where the recovery part became much more important. Obviously, understanding how the fraud worked, stopping it going forward, really important, but the recovery side, equally important. And in fairness, it's built an industry of recovery professionals. One of the first hurdles I always came over, and it's an interesting thing to have in mind, is that when people take things, they take them cross-jurisdictional, usually. They try and put together a complex web to try and hide where things are. And the starting point often would be the good money after bad. You know, do we spend money after this? How can we get this back? This is in a really difficult place. You know, this guy's now got a substantial hotel business in Vietnam. How am I going to get that back, for instance? And the one thing I would say is the first thing you have to look at is if a person's taken something, he wants to be able to control it. No one takes things to a difficult jurisdiction to lose control. So actually what we have to look at is how the asset is controlled. And I don't speak an awful lot of Portuguese. I did pick up the reference to Vietnam in the introduction. And it's a good example. I mean, Vietnamese case is a good example whereby the court systems in Vietnam, and apologies to anybody who has empathy with the Vietnamese system, the court systems in Vietnamese lack some form of credibility. I think it's probably the best way of putting it. They're not very reliable. You can have a very good case and still lose if you're against the wrong people at the wrong time. So actually relying upon the court systems in Vietnam to get back something that's clearly yours is quite difficult. But of course, if you establish that a hotel chain or hotels in Vietnam are actually owned through a holding company that's owned through another holding company that's owned from the Cayman Islands, then you can take control of the Cayman Islands company. And through sort of appointments on the register by taking director appointments or whatever, you can then take control, avoiding the court system, of the asset in Vietnam and practically realise it. So one thing, the first element I would sort of say is, obviously you're looking for assets, but you're also looking for how that asset is controlled and how there are ways to get control of that asset. And in the main, whilst the offshore centres may have a repute for being lacking in transparency or whatever, in the main, they are quite credible. If you bring proceedings in the BVI, you will get the right result. So once you've established the ownership structures, it shows the importance of being able to sort of bring proceedings in the BVI. And I mentioned the BVI because we got a practice out there. And one of the unknown sort of knowns, if you like, I think I don't know how many companies the BVI has now, but it's substantially more than the people in the BVI. And I think it's 45% of those companies emanate from Latin America. Now, if you asked anybody in the BVI where the companies came from, they'd say Russia, because that's all the litigation and whatever. But there's about 8% of Russian companies in BVI. The rest are China and Latin America, and a good amount of the Latin American companies emanate from Brazil. So so the BVI, once you get to the stage where you understand where assets are held, then there becomes a mechanism, and it sort of unravels the complexity of international recovery, because that's the first level. I mean, that we'll go in more in relation to powers of insolvency, but of course then that overlaps with, well, how can you then get control? And that could be via director appointments, but more often via insolvency appointments, which then avails you a whole bunch of investigatory powers in various jurisdictions and recognition ability in various jurisdictions, which then it's like a spider's web which goes outwards into what is then available. And it starts off from what would have been perhaps 15, 20 years ago as this is too difficult, let's stop this, let's stop the money going, but we can't do anything about it, we just have to write that off and move on, it's too difficult. But actually, it is difficult, there's no question about that, what we do is difficult. You're always against somebody who's well-funded, 2 steps ahead, knows exactly what the structures are, they're working with people who create the structures, and therefore they're very mindful of which are transparent jurisdictions, which are not, which ones they want to work into, which ones they don't. But there are still ways of getting through this. If you look at both where the location of assets are, and where the control of the assets are, and where are the jurisdictions that really help you in that process. And I'm sure we'll come back to the US, and the US is a great way of helping you in quite a lot of discovery processes. I just sort of finish on my point of view as well, is another thing, if you're starting off this investigation, I'm always a simple man at heart. I like to keep things simple, then I can understand them. Fraud investigation is quite straightforward, in a way. It's quite straightforward, but a lot of people miss one element of it. And there are three elements to fraud investigation from my point of view. There's somebody that's nicked something. There's something that's been nicked, first element. There's secondly somebody who's nicked something. And most people get that. That's pretty straightforward, even for me. The third element, and you should always think about the third element, is there's somebody who's helped. And there is a global industry of people who are well-funded who help fraud. And in relation to how we start fraud investigations, you always must be mindful of where else you can get the value of that asset back. It's not just going after the asset. It's not just going after the individual. It's making sure you're aware of people who helped in that process who can give you another pot of gold to go after. And those are the basics, really, of how we start that process, and why the offshores, for instance, are very, very critical for that because of the control issues. And why, actually, the first reaction of that could be too difficult, you almost want to sit back and look at it. We'll come on to how those sorts of things, are they cheap? No, they're not. How can they be funded? There's ways of doing that we'll come to, I'm sure, later. But broadly, as a sort of starting point of where you start these processes, I tend to think those are always good lessons to learn. Andrew.
Thank you, and thank you for the introduction. I'm going to start with a very brief apology. I started to come to Brazil 20 years ago, and if I'd known 20 years ago that I'd be working down here so much and speaking to you guys this morning, I would have made more of an effort to learn Portuguese. So I'm very sorry that my Portuguese is limited to menu Portuguese. I think I want to endorse what Henrique says. I think what's really important to get across is how Brazil is perceived outside of Brazil in terms of this field of work. I think the court system here over the last 20 years has changed immeasurably. Even well before on-trial model law was adopted, the Brazilian judiciary here wanted to learn, they wanted to understand, they wanted to see how other courts would recognize and assist trustees in bankruptcy appointed in this jurisdiction. And if I may say, the work that DFA and others have done over the years in helping the judiciary and educating the judiciary is now seen internationally as a sort of a gold standard. And I really mean that. I mean, if you go, as we do, in London and say we're acting for a court-appointed trustee in São Paulo, then automatically the British court will recognise that the bankruptcy court in São Paulo understands what it's doing. It appointed someone specifically to bring claims outside of Brazil. There'll be a funding model in place, which we'll come on to later. So the level of sophistication in order to now take proactive steps outside of Brazil to recover assets has developed, in my experience, particularly over the last 20 years. But it's got to a standard now where I think everyone should be proud that, as Henrique said, turning up. And just to share one anecdote, when Henrique used to say to me, come and see the judge, I said, what do you mean? In the UK, we can't just walk in and see a judge. We can't go into chambers and have an open door policy. And certainly we couldn't speak to the judge without inviting our opponent, because there will be a perception of we're influencing the judge. And of course in Brazil it's completely different. You go and talk to the judge and you explain what's happening, and you get the support that you need. So I think that's, to me, fundamental, and I think we're proud to represent Brazilian trustees outside of Brazil, and we think now that internationally that's recognised. I think the other thing, just to quickly mention before I pass over, international asset recovery is a complex area, but equally it's now a well-developed and a very successful and well-structured industry. I think introducing insolvency practitioners, as we'll come on to today, is fundamental. It's not just because they have powers that they can use to get documents or to bring claims. If there's a claim against a bank, they can bring it through the company or their appointments. I think flipping it around, and if I may use the example of when the city of São Paulo took steps outside of Brazil on the Maluf case, if you think about that was early 2003, 2004. It's not the municipality's job to start litigation outside of Brazil. It's not familiar with those sort of concepts. It was the victim. and yet it took steps to start litigation in its own name in other jurisdictions in order to seek to repatriate value. Now, I think, again, credit to the city, because they were the victim. They had to engage law firms and other professionals to start the case. But I think the thing I particularly wanted to emphasise is 2 points. One, how do you budget for that? How do you get sign-off? How do you give undertakings to different courts in case there's cost issues? And I remember on one discussion, without hopefully breaching any sensitivities, we had to give certain undertakings to get a freezing order in London, in Jersey. And the city said to me, we need to advertise that in the Gazette here, because it's a public expenditure. I said, well, you can't advertise it. We're freezing assets in secret in Jersey. And so there was an inevitable tension between their role as a public body and us trying to bring a successful project on their behalf. But I think most fundamentally, and again, credit to the city, they ran that case and funded it for 12 years. Through all the issues around political changes at local government level, they maintained that case to a level where they could freeze the assets and get a significant judgment. Now then, of course, that's half two-thirds of the objective. You then have to repatriate value. And that's what we were able to do in that case by appointing Grant Thornton in the BVI as liquidators over the Malufe companies. This is all now public, it's no sensitivity on this. And through the liquidation powers that Kevin and his colleagues had in BVI, we were able to take steps in Brazil, we were able to get information in other jurisdictions and take control. And it's Kevin's point. We now control the assets. They were in a complex structure in Jersey. The liquidators now have direct control and are enabled now to bring a transaction together to get value. So I think it's hopefully a good illustration of we're a victim of a fraud, particularly in a public sector. It's a difficult project for them to run. But having run it for as long as they did, then bringing in other professionals, in particular insolvency practitioners, enabled them to complete the project by now actually having control and returning value for the assets. So we maybe want to pick up on some of those themes during the conference, but again, mainly to endorse Henrique's point that this is a good jurisdiction to do what we do. It's a pleasure for us to work for trustees outside of Brazil, and it always produces interesting and complex work.
Thank you. I have a first question to Nyana. Nyana, you told us about the discovery, and of course it's very important so we can search information to make a plausible cause to a petition. And how long from the day you file a discovery you have access to the full documentation you were trying to reach? And what are the particular difficult you have? Because I understand in the discovery they will send you a lot that is completely useless, and you have to search in the middle of the ocean, I guess, for where the fishes are, right? Can you tell us about these two experiences? Thank you.
Absolutely. That's an excellent question.
You froze for a while.
I think the most... Okay, I'll start over. At the beginning of taking discovery, it's challenging for us, and the first challenge is to figure out who actually holds the information that we want. When it's with an impartial institution like a bank, that can be much easier discovery to take than when it's with someone who is a close advisor or who is an alter ego of the fraudster, right? The person perpetrating the fraud. So let's take the easier one first. With the banks, generally, we issue the discovery and they can respond within 30 to 60 days. Some of them ask for an extension, some of them respond right away. There is a clearinghouse that we also generally subpoena when we subpoena the banks. The clearinghouse takes much longer. They just don't have very much staff, and they get a lot of subpoenas, from our federal prosecutors and state prosecutors, and then bankruptcy trustees and creditors. Everyone is interested in the clears all of the international wires. Not all of them, because we have information in response to discovery. Now it's taking them 4 to 5 months before they can.
Nyana, can you turn off your camera, because sometimes it's cutting you, and we are all very interested. Yeah, I think the signal will be better. Thank you so much, and your picture is very beautiful.
Sure, let me try again. And I'm sure Enrique can clarify. He's taken all of this kind of discovery with us. We have other types of discovery. So I'm actually thinking of the case, Enrique, I was looking at yesterday, because I sent an update to the judge trying to get some of our discovery. And unfortunately, in that case, we are subpoenaing the New York attorney who was advising the fraudster, the perpetrator of the fraud, in setting up all of these offshore structures. So we already did receive many documents from him, but it took much longer than normal. And there are some emails that he received and sent in the days right after the fraudster received notice of a medida cautelar in Brazil. So we want to get our hands on those emails. And so in that case, it has taken much longer for many reasons. We had to argue, several hearings before the judge here in Miami. The fraudster alleges that these are protected by the attorney-client privilege, but there is an exception to the attorney-client privilege when the attorney is aiding or assisting in the commission of a fraud. So that is the issue that the American judge, the Florida judge, needs to decide, is whether those specific emails are in assistance of a fraud. So yeah, I can see you nodding. So you understand certainly that this is a very sensitive issue, and the judge has not been quick to decide that issue. But that is an extreme case. So generally, most discovery that I have taken in all of my cases, whether domestic here in the United States or international involving Brazil or other countries, it takes between 2 to 3 months on average. And then if a legal issue arises and you need to go to hearing and, argue about exactly what is permissible discovery, then those things tend to take a little bit longer.
Thank you so much. Thank you so much.
If I may add, I think Nyana gave a very good explanation about that, but it's interesting to understand that the discovery that you can take in the U.S., and Kevin, I'm sure is going to add to that, is that basically anyone that is their jurisdiction is going to have to help the court to understand what went on. And the way it works is that you ask for information, they give you information, you ask for more information, and you keep completing the gaps of what's going on. So we had a very interesting case of a Brazilian insolvency that had a huge art collection globally. And interesting enough, the insurance company that was insuring very expensive artwork, the artwork was in Switzerland, but the insurance company was in the US. So when the Brazilian trustee recognized the proceeding in the United States, Nyana's firm was able to issue a subpoena to the insurance company and ask for all the information. And when we got that information, there was a clear evidence that few years after the fraud, the same individual continued to, like Kevin said, control the assets. So that person was still the owner of those assets, although they were not in the United States, and it would be much harder to get information like that in Switzerland. The US proceeding was key to help to understand. So, and another point which is quite interesting, the money center banks, the banks that clear transactions between countries, and I think our president is currently in China trying to figure out a way not to use the US dollar anymore, but I don't know how that's gonna work for purpose of asset recovery, but it might get harder. But every transaction around the world usually passes through the United States. So even if you're buying you are from Chile and you're buying a house in New Zealand. The money is not going to go direct there, even though you could take a flight direct to New Zealand. But the money is going to go to the United States and then go to New Zealand. So that's key for us in asset recovery. That's why when we kick off proceedings, we usually ask for the clearinghouse and the money center banks to give us data. And you're not only looking for the one mistake you usually make when you kick off on an asset recovery project is that you're looking for the high value assets. And that's not what you're looking for. And we have good case law in Brazil. On one case that Otaviano did the oral arguments in Rio recently, that they said that using a company registered in the individual's RIS for 10,000 reais, it was controlling over a couple $100 million of assets globally. So the value that you see on the documents doesn't mean that's the value behind the structure. I don't know if you can add to that, Kevin.
I mean, well, yeah, it's absolutely right. It's very often you'll have a company which on the face of it has nothing, controls significant sums in multiple jurisdictions. And one of the interesting ways that people have used to sort of hide things is you end up setting up a company in some weird and wonderful jurisdiction and then just allow it to fall off the register. And so effectively nobody controls it, but the perpetrator does control it. But of course, because it actually there was nothing exciting about it, it's all, what we call in the UK a £1 company. Then nobody it's not obliged to do accounts in that respect because it's not registered what's there. You create it because it then has the element of control to the extent that if you're looking at doing searches wherever else in the world you are, you won't necessarily pop up details of the individuals you're looking for because it's all held in a company name. But when you try and investigate the company, it's no longer there. And I think we did something quite recently in the UK, and so this is a jurisdiction which you might perceive to be much more highly regulated in those sorts of things. But I think we found something like 45,000 plots of land, registered land, and not all land is registered in the UK, but 45 plots of registered land which belong to companies that have been dissolved. Which is a bizarre thing because you think, why would you own a house and allow the company that owns it to fall away? Because obviously you potentially lose your house. Because we have a great system, which Enrique is very, very keen on in the UK, that if you have a company that falls off the register, the assets go bona vacantia. They go to Prince William, as it now is. Used to be Prince Charles, but he's had to renege on that and pass it over in his forthcoming sort of kingdom, so to speak. Yeah, so in theory, the way it should work is if you have a company and it falls off the register, by definition, its assets just go to the Crown in the UK. But of course, they need to know about it. So it's quite an interesting, and we've got a case at the moment where we're looking at that because it's quite an interesting process where you can have corporate vehicles that on the face of it are either not in existence or certainly have no standing of any credible status from a financial point of view. But when you sort of drill down into what it is they own, or often the case, they own structures or have an important part in a structure, which then you get down towards the bottom, will have a really, really dominant position in relation to substantial trading companies.
Let me just want to add an interesting point. So, Kevin, when I heard of that the assets would go to the Crown, I was happy because I was expecting that our case could turn into one of the chapters in the Crown in the series soon. So I told our courts yesterday here in Brazil that we're now opposite to Prince William. We used to be opposite to Prince Charles, but now he's the king. So it's the first time we're suing a monarch from a Brazilian insolvency proceeding, suing the Crown in England.
And as you probably know, you never quite know when Enrique says something, whether it's true or not. That's true. That was true. That was yesterday. And that's on a case in London where we're looking to restore some...
And we're taking auditions as to who's going to take the Enrique part. Any suggestions greatly received.
How do you search the assets? Do you look when you have these BVI companies that you mentioned? So I understood for what you said that's mostly, not all, but mostly BVI companies are done to set these structures. So how do you share and how do you connect the debitor and the asset? I assume that they're bare shares, né, ações ao portador, or I assume there are lots of companies, one owning others, and that makes you to hide, not only hide the assets, but to stop the link of the debitor and the asset. How do you come to that in these structures in BVI?
I think that's, well, in the BVI, I mean, it's the same question in a number of jurisdictions from that point of view, and the BVI has prevalence because of the amount of use it gets from Brazil. But it's a very good question. It's a very good question, which there isn't one straightforward answer for. I could say it depends who you're acting for, because certainly the BVI has become less opaque, more transparent, but only in relation to revenue services. So they do have an obligation now to provide full information, but to revenue services. And in fairness, you know, that. So if you are working ultimately for the Crown, back to the Crown again, that helps from that sort of side. Having said that, Nevis has become more opaque, spotting the opportunity, if you like. So you're still faced with the same problem, but maybe in a different jurisdiction. And I think the simple answer to that is it's not simple. But there is a variety of different sources of information that you have to put together as part of a collective investigation, which then gives you information. So, for instance, I don't know, if you have a BVI company that owns a yacht, and if you're able, by using technology, to show that on somebody's Facebook account they went on holiday on that yacht, you know, 2 years ago, whatever, that then gives you a strand of linkage between that individual and that company. Then you start to build on that process. Quite often, social media is really, really important for putting strands together. Quite often, victims' children like to post about their holidays. You know, you'll find properties you didn't know about. You will find service charges being paid by accounts that don't relate. So quite a lot of it is very much going back to basics in getting a lot of data. And Henrique mentioned data, and we've talked about, Nyana, the importance of sourcing the data, then going through the data to try and find out that. I mean, very few people are complete ghosts.
Oh, thank you. Andrew, as we see, we have a lot of people searching for these assets. And I heard from you in the beginning, you started working in a case like 15 years ago. So how we provide the costs of all this?
Yeah, that's an important question as well, because inevitably, particularly if you're talking about a fraud situation where the victim has lost money, they're reluctant to fund, particularly on an open-ended basis. So what you need to do is, it depends on the situation, but there's definitely now an ability to invite professionals to work on risk. So professionals will invest in the case in terms of their own time, and in certain situations, particularly, if I may say, with Grant Thornton, they're prepared to put in some seed capital to look at a case. There's also the ability to go to the market to get professional funding. And one of the things I was going to mention, and if I may, I'll do it in response to your question, there's 2 points. I mean, obviously, some companies are just set up to hold an asset, and as Kevin said, they may be left to be dissolved. They're not active, they're not trading. But of course, in a liquidation, however dormant the company's been, you want it to trade. You want it to do what it needs to do, recover its value, recover documents from lawyers, professional advisors, accountants. So you want the company to be active. And so the liquidators come into a company and they have the ability to reactivate it. They're directors. They take over the management of the business. But of course, like any business, it needs working capital. So there's a dilemma there. But you can go to the market, for example, and get insurance products to protect you from risk of costs and other challenges in other jurisdictions. So you have to, as part of any asset recovery project, and they are projects, you have to have a big eye on how's it going to be funded. And I think it's fair to say, again, in Brazil, the courts here recognise that if you've got an estate, and some of the estates we've worked on are historical. You know, they were talked about 10, 15 years ago, and the domestic work in Brazil has largely been done. But because the way the market's now opened up and developed, we have situations where trustees are appointed simply to run a case outside of Brazil. And that needs to come with a funding solution, because you can't say to creditors who may have had a distribution in 15 years ago, oh, can you provide some capital? So it has to be an understanding, and often professionals would take an investment on a case. But I think, can I just make one point, which I'm going to emphasise is as important as Henrique's point about freezing assets and the sophistication in which you can freeze bank accounts in Brazil. And this is a fundamental for people like us working on these cases, and we have to explain this regularly to judges in other jurisdictions. Here in Brazil, you'll have a bankruptcy, and you can pierce the so-called corporate veil, so you can visit the debts on the individuals who had control of the entity. And this is fundamental. So, for example, the artwork case that Henrique was referring to, of course, this is artwork not owned by the company. This is an individual who furnished his house with very expensive artwork that he amassed worldwide. But as long as you can say the debts of the company can be effectively brought on the individual, and you can get individual assets and bring them into the estate, that makes us taking a risk on a case a lot easier. Because you don't have to run litigation against individuals, you sort of bring it into one pool.
I suppose this is why insolvency procedures are so important to you guys, right?
Sorry, Henrique.
On your job.
On two levels. One, getting back to where we started this discussion, here in Brazil, the framework works well, because you can put a business into bankruptcy, you can pierce the veil, you can make sure the directors or the owners of the business are responsible for the debts. And then when that is taken abroad and recognised, and people like Kevin, myself, try to recover assets, we know that if we find an asset, even in an individual's name, it can be repatriated as part of that project. Fundamental.
Yeah, I would add, that's why I think Brazil is leading, I would say, with other jurisdictions, the asset recovery world, particularly in terms of insolvency. But it's not, our courts here have on a number of different times when you show that an individual owns an offshore company, and he's managing that offshore company, he or she are managing from São Paulo, for instance. So there's a fraud, you have a bankrupt state, and you have the same person behind the insolvency now managing assets through an offshore company out of São Paulo. So you go to the bank, the statements are sent to São Paulo. Not anymore because it's electronic, but it should be addressed to São Paulo. And you go to the KYC information in the bank of that offshore, Nyana can get it from the banks in the US, and it says, this money comes from the operation of that company. So they have to provide a reason for high value money to be moved around the world. So on the artwork, for instance, case, the assets were in Switzerland, the insurance policy and documents in the US, the owner of the artwork in Switzerland was a Panamanian company, and everything being managed out of São Paulo. So our courts on that case said, I have jurisdiction over the offshore companies because we got an opinion from a Panamanian lawyer saying that offshore companies can operate outside of their jurisdiction. For instance, I believe, Kevin, correct me if I'm wrong, but in BVI, for a number of years, a BVI company couldn't operate in BVI. So it was registered there, but it could only operate in another jurisdiction.
How do you prove the assets were dragged from the insolvent company?
So every case changes, but sometimes, you have situations where there's a diversion of assets from the company through a loan to the shareholder, for instance, or a transfer, just a transfer. They go there, there's no documents to support the transfer.
So you follow the assets or the money?
Usually you try to first prove there's a fraud. Okay, if there's a fraud here, who's the beneficiary of the fraud? And then you look at the asset and you say, who owns that asset?
Tell us what is a fraud from your perspective?
Their perspective or ours?
All of you.
I
We're here
think, look,
from you.
Companies, how do you take money out of a company, right? The way that you take money out of a company legally is by paying dividends. It's by, sometimes what happens is that they pay dividends when you're not allowed to pay dividends, but so that's just a way of taking the money.
We are here from this
quite
subject right now in the papers.
Yeah, so another way to take money out of a company is to give a loan. Sometimes those loans will put you insolvent. So the purpose of that company is not to trade and give the shareholder a loan.
So the loan is not real. That's where
It's
the
an
fraud
abuse of the
is.
corporation. They're using
Okay.
the corporation for what it was not put together for.
The loan is from you in another pocket, right?
Another way is, you just buy assets that are worth nothing for a lot. So I go and I sell my car for $1 million to the company. There's a number of ways that frauds take place by, kind of stealing the money from the company. When we get to that point, you're going to make someone liable. Someone authorized that, someone benefited from that, So that's your connection to the fraud. And then you go around that person, like they said on social media, forensic investigations, and you find that someone connected to them is buying an apartment in New York or in London. You have the connection. When you get to that point in litigation, the burden shifts. That person that has the asset now has to show that it doesn't come from the situation. So that's more or less what we see from the Brazilian side. I don't know if you guys want to add from the US, Nyana, or the UK team here.
Do you have more time? I have some more questions. Are we? A gente quer Oh, I think we...
Sorry, it may be an opportunity for Kevin, because it's a fair question, and every situation is different. And there are some situations where you go back to the source and the money's left the company and you literally follow it step by step by step. Some situations, there's a gap for obvious reasons. Some of the cases I've done out of Brazil, there's been doleros involved, so you have no ability to forensically trace the money. So you almost have to then work backwards. You find what you think is the asset and you get as close as you can to join. But that's more your...
Yeah, and the UK works on, whilst we're looking at fraud, it's still civil, so we're on a balance of probabilities. So often, forensically, great if you can follow the money, great if you've got 8 bank transactions and you've got all the documentation, that's easy. Where you start to have gaps, cash, for instance, creates a gap. Then you have to create a picture where on the balance of probabilities, the court is satisfied that actually you've jumped to that level. Now, interestingly, having what we just said about the court processes in Brazil, the English courts are becoming more prescriptive about the information they want to see to be able to make those jumps. I would say my experience is that they're more debtor friendly than they were, and less creditor friendly than they were.
So this was going to be my next question, and you have to work like a FBI in the sense of, yes, you have to use the information in a very intelligent way. So to interpretation of the information is really important. So you told us the Brazilian system works, and Nyana told us about the discovery. How cooperation between these jurisdictions is working as a central model that Brazilian law has just put in our system since the past 2 years?
I can start, if I may. I haven't myself worked on a case that has sought recognition here in Brazil, but I know Kevin has.
Can you tell what the case is? So tell the name. Which one?
There's a case.
Is it SAS?
I don't know. The FA team here, I think it's public, right? Yeah. So
Yes.
there's a case out of Paraná, which is called Goodman. They are appointed by BVI court to represent Goodman. The government was 99.5% shareholder of a Brazilian company.
Company here.
Yeah, I think it's Clarion, the group. The name of they
Okay.
should be public traded. But the Paraná court recognized the BVI liquidators as foreign representative for the first time on an insolvency. And I know there's a case out of Rio that was a recognition of a Singaporean reorganization proceeding that was recognized by the real court, but that was on a Chapter 11 situation.
Oh, okay.
But on a full liquidation, I think this is the first judgment, and the judge was, gave a very detailed judgment. It's being appealed as expected, but now as shareholders, the liquidators are in Brazil as foreign representatives and shareholders of a Brazilian company, so they can ask for information, they can look at the books, records, understand what's going on, and even remove managers.
Okay. Andrew?
No, I'm just going to sort of, if I may repeat the other point, in an informal way, recognition has been working very well anyway in terms of comity and requests of other judges. Like, we've regularly appeared in the BVI, and we've issued proceedings that have an impact here in São Paulo. And the BVI court will issue a letter of request to the judges here and say, can you please assist in this important matter? And so there's a lot of judicial support. And I think, again, I think I said this earlier, now that Brazil is formally part of Insolvência, it'll be interesting to see how many cases come back this way. I guess the question is how many people take money from other jurisdictions and bring it to Brazil. I don't know. I mean, I think we've seen the tide going the other way.
We're currently looking at 4 other cases to file in Brazil now. So there's a lot of people that own assets in Brazil and they have insolvency proceedings abroad.
Yeah, and I think I was being slightly... I think the important thing is, of course, there will be records here, banking records, other records. So I think overseas liquidators will come to Brazil inevitably to try and get support from the bankruptcy court in terms of discovery. It's inevitable.
Nyana, can you hear us? Is this coordination between United States courts and Brazilian courts are working? Their coordination like the UNCITRAL model asks us to do?
I think it's absolutely working. So thankfully, most of our coordination does not have to take place by Zoom on terrible Wi-Fi internet. But in the legal proceedings, that I've been a part of, the courts in the United States are very receptive, on the Chapter 15 side, right? So where the U.S. is rendering assistance to Brazil, I think, like Henrique said, I think the American courts are increasingly recognizing that Brazilian courts are very serious about the way that they do their work in the insolvency. That they when they request assistance, that those requests should be taken seriously. So I've had cases where there were long debates about what assistance is necessary, and there was confusion over here in the United States, usually caused by people who didn't want the evidence to get out, right, about what was going on. The Brazilian judge was able to clarify what issues were being debated in Brazil and what evidence was being sought in order to assist in that fact-finding mission. I have seen, the American judges jump to action as far as authorizing discovery and making sure that discovery goes back to Brazil.
Thank you. Does anyone here want to ask something? Joyce? 10 minutes, I heard that. Thank you.
Is that a question?
No. Oh, yes. Which?
No, we're not taking questions from Marcelo.
Why not? No, Marcelo, you have to go here because otherwise Nyana won't hear you.
Thank you.
Yeah, but I agree with Henrique. I've already answered all of Marcelo's questions.
Thank you.
Good morning, everyone. Marcelo Lucidi here. Nyana mentioned about, and actually Nyana and Andrew mentioned about how U.S. and English courts perceive the Brazilian courts or the Brazilian trustee whenever they require assistance abroad. But I was just wondering, what's the perception of the panel about how does Brazil compare to other jurisdictions in terms of duration of proceedings and reliability of the courts?
Thank you, Marcelo.
Well, I'm probably the least qualified to answer that, but
Go ahead.
Well, honestly, Marcelo, we hear stories about things getting caught up in some judge's desk in, wherever. But in my experience, if you need sort of to intervene with the judge or the system, you're heard. And things, there are regular hearings. Yes, everything gets appealed. I guess that's the nature of the work that we do. But does the system work? Yes. I mean, and I think Kevin, I know you're.
Yeah, you can. The problem with these things, you can really go from personal experience, can't you? If you had a bad experience, it then overlays every other good experience. And I think my personal experience of working in the court system in Brazil probably relates largely to the case we mentioned earlier on in relation to our involvement in the Malufo matter, where that's always been pretty good, and certainly the avenues open to us, and they were considered more strategically than practically, if that helped to the extent we haven't actually gone down all the avenues we could have gone down. But certainly in relation to the proceedings we've done, they've been predictable, and anybody who wins proceedings is going to say the outcome was the right outcome. But I think that there are jurisdictions I've worked in where the proceedings are far less predictable. Let's put it that way.
Nyana, would you like to say something about that? And after that?
I think, in countries as large as the United States and Brazil, there are tremendous regional differences. The positive thing is that the parts of the country that tend to deal with the cross-border cases tend to be the more sophisticated courts, right? So the courts in the United States that have become kind of specialists in Chapter 15 are in the Southern District of New York and the Southern District of Florida. If I go to the Middle District of Florida, which is Orlando, and Brazilians think that Orlando is part of Brazil because there's so many Brazilians there, but it's really not. In the sense of international trade and real international business, it's really not. And so it doesn't end up seeing as many international bankruptcies there. I've had a few. I think I've had one over in the Tampa area, and it was the judge who presided over that Chapter 15 case. It was only her second Chapter 15, right? Whereas the judges in the Southern District of Florida, they see Chapter 15, a new one every month. So there's a tremendous regional differences, and I've seen the same in Brazil, right? I have, great worries sometimes when the bankruptcy is coming out of a state that doesn't see very many international cases, and the judge who's dealing with the cross-border case has only, perhaps dealt with offshore assets once or perhaps never.
Thank you, Nyana.
So just can I just add a practical example to that, just to give you an idea of what it is like doing international asset recovery. Just do, I won't mention the jurisdiction, but I got myself involved in I think Henrique knows where it is, quite a difficult asset recovery process, quite frustrating because a lot of court work needed to be done, of course quite unpredictable. And we had one part of the matter, whereby we discussed whether or not we need to appeal it to the Supreme Court. And I was given advice to say we don't need to, it won't cause a problem, off we go. So we didn't do that, which was useful. About a year later, when we were actually realising assets, it then became apparent that we should have taken the matter to the Supreme Court because there was just some issue that came up which meant, we should have done that. And so I was obviously quite frustrated at that time. We'd lost a year. So I had this conversation with the lawyers, and it went literally like this. And I sort of said, okay, so timings, where are we? How long will this going to take? And I'm used to the Supreme Court in the UK, 2 or 3 years you're looking at maybe by the time you get to judgments and things, And so I think this was in February or something. And the guy said, we can get a hearing probably by mid-April. So I think, okay, I'm a bit more relaxed about that. It's obviously slightly different, that's fine. And I said, okay, then costs. We need to fund the costs. How are we going to do with the costs? And they said, Supreme Court's about $25,000. And of course, I'm used to $250,000, $500,000. So again, I started to relax my slightly sort of frustrated state of earlier. And I said, okay, let's talk to me about merits. And they said, merits? I said, well, yeah, what's the merits? What's our chances? They said, it's $25,000. That leaves you with a bit of a problem. But but it shows you the difference of the challenges you get in certain court systems. But I mean, it's a slight interesting nuance, but I mean, it does show that there are jurisdictions whereby, as it happened, it isn't quite as predictable as that, but I mean, it was interesting in that jurisdiction because there's lots of enforcement's been done by banks and whatever, you can't do. You can't operate through the formal process because of the way the process works.
Yeah, let me just maybe add 1 minute, less than a minute. I think we are on the top. We're on the top. I would say 5% of the world in terms of being efficient, liable, and something transparent. I would think we're definitely first world in terms of our court system.
It's really nice to hear from that. And Henrique, I invite you to wrap up, and so we can finish on time, as our president said.
All right. Look, I think a lot was said, a lot was covered. I wish we had, other opportunities, Joyce, if we can come back, with other topics, the cryptocurrency issues I think we didn't touch. But there's a lot we can do. It's an efficient process. Our courts are favorable to it. I haven't seen any court order saying, don't go abroad, don't try to recover. It's just not part of our system, right? So what I would say is that we gotta, work to convince our judges here that when the party is not dealing with the merits of the case, don't give them 150 chances to appeal. Rule the case, make a decision, determination. And that's, I would say, the only weak point that we're still at, and we need to work hard to try to make our system more efficient. But again, thank you. Thank you guys for joining us from foreign jurisdictions. Thank you, Nyana. We're now seeing you, and I would say we heard about 93% of what you said.
Yes. Thank you, guys. So by the time we are done. Thank you so much, dear me.